Good evening, and thanks for taking the time to address this important issue. My name's Alana Sakovitz. I'm an attorney with the Workers' Side law firm Virginia and Ambinder. We represent workers with their harassment, discrimination, and unpaid wage claims. Pregnancy discrimination is one of the most common and most insidious forms of discrimination that our law firm handles. A New York Times article reported that according to a 2014 analysis by the University of Massachusetts, each child chops 4% off a woman's hourly wages, while men's earnings increase 6% after they become fathers. Pregnancy discrimination may account for at least part of this. Far too often, women, from those in minimum wage to white-collar jobs, contact us with stories so familiar they could follow a script. Shortly after a woman reveals her pregnancy, she begins to receive negative performance reviews at work, is passed over for promotional opportunities, and is excluded from work assignments involving travel, client meetings, networking, and social events with coworkers, even if it's drinks after work. Requests for accommodations are ignored, and women are written up for excessive absences, even those absences that are for pregnancy-related doctor appointments. Supervisors and coworkers speculate about whether she will return to work after giving birth, and more than once we have heard that there's an office-wide betting pool on whether the woman would return after parental leave. Eventually, for those women who aren't terminated prior to taking parental leave, they attempt to return to work only to be informed that their position has been eliminated. They're told that their return date has been pushed back, and after speaking through several HR representatives, they're told that their job no longer exists. This is the employer's effort to say that it's not the employee who's being terminated, it's just their position. They may be offered the opportunity to apply for alternate positions, only to find out that no comparable position exists, or to not even be selected for an interview, even if they had worked for the company for more than a decade. They may be offered freelance work in place of their full-time salaried job with benefits. In nearly every such case that we have seen, we have received the exact same response from the offending employers. The termination was part of a reorganization. Although it quickly becomes apparent that the only position eliminated in this reorganization was the pregnant woman's. Additionally, for the many women who are terminated before giving birth, they are faced with the arduous task of searching for employment with an increasingly visible pregnancy. As employers are ostensibly less likely to hire a woman who is visibly pregnant, they are often condemned to months of unemployment with very little chance of re-entering the job market until after giving birth. These examples are an amalgamation of the cases we have handled, and though the facts may vary, the story arc is the same, and it begins with a pregnant woman and ends with an unemployed one. For these reasons, we have two requests. That in recognizing the unique challenges a pregnant woman faces in entering the workforce and the irreparable harm she may suffer remaining unemployed while pregnant, and in the interests of deterring and curtailing this, a rebuttable presumption of discrimination be applied to employers who terminate women during a then known of pregnancy. And that the New York City human rights law require employers to adopt a pregnancy discrimination prevention policy and training for employees. Thank you for your time.